to make sure that I mentioned the wonderful sponsors and partners who really are our community, who make this possible. So that is Nouveau Florida. That's Oracle Profitability, which a couple of people last time didn't realize that they are more in the accounting field. They are not attorneys. The Paving Lady, Plastridge Insurance, who we had last week, South State Bank, United Professional Engineering, Vote HOA Now, City Quiet, Easy Management. You see that as Easy MGT. They're brand new, so welcome. The Falcon Group, Hotwire, KBR, and I think that's everybody. So I just want to say thank you to everybody who makes it possible for us to do this. Thank you, Jeff. You're just the best Zoom host. And he gave you guys some incredible resources. Once you fill out that evaluation form at the end of the webinar, you'll have all those nice resources. So everything from finding us on acebytsk.com, where you'll see all the webinars each week, to some other great opportunities, connecting with Lisa, connecting with KBR. We're connecting with some of our other partners. So thank you to Jeff. And with that, I'm going to let Lisa get into it because she's fantastic. And I'm sure that there's a lot to review today. So with that, Lisa.
Thank you so much, Ariel. Thank you. And thank you for joining us. So today is focused on HOAs. The reason that I decided to start with HOAs at the time that we organized this, the HOA bills were not only passed, but they were signed into law by the governor, most of which take effect as of July 1. Just recently, the governor did sign the big condo bill, which was HB 1021. That has a lot of significant changes for community condominium associations. So please make sure that you can stay tuned. For that, so that we can talk about all the changes that you HOA directors are going to need to learn about. The HOA laws, some people are taking a little bit of umbrage at them because of various reasons. You have to understand, when it comes to legislation, the way legislation gets introduced and modified when it goes through the session is that it's all based upon constituent outreach. So there are legislators up there in Tallahassee. They listen to their constituents. They get phone calls at their local offices or their Tallahassee offices. You know, people describe what things that are wrong or right or what have you. And then the legislators react by creating laws to address the issues that they hear. Okay, so the major bills this year for HOAs was 293, that was regarding hurricane protection, 59, that's regarding distribution of the covenants and rules, and HB 1203. We're going to spend the bulk of our time talking about HB 1203 because there's a lot of information in HB 1203 that pertains to not only just regular operations, but pertains to board of director responsibilities and duties, educational requirements, CAM educational requirements, architectural control, rulemaking, and rule enforcement, and the like. Beyond the main bills that we're going to talk about, there are two other bills that have somewhat slipped through the attention that's been given in recent times when it comes to Florida legislation concerning HOAs. One is regarding revitalization of the covenants. That is the MRTA revitalization. So just as a little bit of background for HOA covenants, declaration of covenants, there's a law called Marketable Record Title Act that basically says, and this is a very, very basic overview, after 30 years, the covenants will be extinguished unless they have been preserved in compliance with the statute. That's Chapter 712 Florida statutes. Well, many years ago, people realized that covenants had been expired because they were in existence for more than 30 years, and there was no mechanism to revitalize the covenant. So the HOA Act, Chapter 720 Florida statutes, contains an entire revitalization procedure. It requires the approval of the majority of the entire membership to revitalize. So my advice to everyone out there, if you can, or please make sure that you preserve the covenants before they expire, because the preservation process is so easy and simple and not expensive. The revitalization process can be cumbersome. It can get expensive depending on how much outreach you need to do to obtain the consents from the requisite members. And then once you do take all the actions that you need to do, the documents are sent up to the Department of Commerce. It was the Department of Financial Services. So that's what changed this year and now refers to the Department of Commerce. And when you send it, it has to be sent. This is what the change is. And this is what the department's been going by in over the past several years. It has to be sent within 60 days of the day that you get the last consent to get the majority. So you may have 100 owners, and you know that you're going to have like about 60 people voting. So when the 51st one comes in with the yes vote, or the written consent in favor of revitalization, you think, oh, we'll give it a little bit more time because I know that, you know, this one hasn't voted and that one hasn't voted. Well, what happens is that by waiting, if your submission is not in within 60 days of that 51st consent, then the department's going to kick it right back to you and say that it's not compliant, and they make you do the whole thing over again. So this has made it clarified that it has to be submitted within 60 days of the day that you get that one consent that puts you into that majority category. Now, if you're doing the work, you're doing the consents at a meeting, you're going to file within 60 days of the meeting. And of course, if you postpone or recess and reconvene your meeting, the meeting isn't over until you finish the reconvening process. That has to be done within a 90-day period because the proxies are only valid for 90 days. The other statute that went a little bit unnoticed was, it's just a tiny little segment of a much larger statute, SB 1420, and it does have a little blurb about prohibited issues in community association or condo declarations of covenants for homeowners association communities. So what that says is that the association cannot prohibit fuel sources to serve customers, whether it's from a public or electric utility or cooperative, natural gas utility, liquefied petroleum, and you can't prohibit the use of appliances that use these sources. Why is this in here? Well, I think it has a lot to do with the other bill involving hurricane protection. I know in my neighborhood, most neighborhoods don't even have gas as a service. My neighborhood happens to have gas as a service, and it was already plumbed to my house when I bought my house. So I love the fact that we have it. I mean, I use it for, many appliances use it. Of course, your gas grill uses it, and it's just a fabulous thing to have. But other people in the neighborhood don't have the service that actually is connected with the house. So they would need to contact the utility and make arrangements to be connected to the house. If your community does not have gas service, the owners may be thinking if they wanted to obtain a permanent generator, they may want to have a tank or a storage tank embedded into their property. And I have a neighbor that did this. I don't know why. They decided they wanted the liquid petroleum as opposed to the gas from the utility. And you can't even see it it's in their front yard. There's basically a 2-inch round cap that provides access to the fuel tank. As they've had it for several years. I've never seen them fill it. We haven't really had any major hurricanes or power outages since they've had their permanent generator and they've had the storage facility. But I think that's the reason why this statute was enacted, and it really raises a lot of questions or concerns for HOA leaders when it comes to your architectural control provisions. And a lot of the law, particularly that in 1203, talks about architectural control, your architectural control procedures, and what is going to be viewed as appropriate for HOA architectural control. Looking to, okay, so when I looked at this, and we're going to talk about it later, I thought I remembered a case back from when, well, it's one of the seminal cases associated with condo HOA rulemaking that talked about burying a storage tank. I'm going to talk about the case later, but it was really concerning uh, digging a well on the private property owned by that condominium owner. We're going to talk about it because we're going to say we're going to go through what the board there evaluated when determining whether or not they wanted to approve the installation of a new well and how the court handled it. So here are the two small bills that we address right from the first slide, Hurricane 293, hurricane protection. So HOAs now, you need to adopt hurricane protection specifications. So hurricane protection specifications, protections includes roofs, storm shutters, impact glass, reinforced garage doors, erosion controls, generators, fuel storage. I mean, there could be all other types of hurricane protection that is not necessarily specified in the statute, but now you're going to want to have guidelines and of what the association will accept or will not accept. Just like in condos have had to adopt hurricane specifications for many years. Initially it was on the shutters because owners were allowed to install shutters, but the shutters had to conform to the specification. So you can specify the style, you can specify the color, you can specify the mode of operation, and other items that are important to you. This bill does not address when the use of the hurricane protection. So that's another issue that you may want to think about, because many people leave for the summer. This is South Florida. This is Florida. People go other places, whether they go on vacation or whether they go to their other home, if they're lucky enough to have another home, and preferably a place that has a little bit cooler temperatures. But this is hurricane season, so they want to put up all their hurricane protection before they leave, and then they don't address it again until they come back for the summer. This bill did not address that issue. So if that is an issue in your community, or is that something that you want to address in your community, I encourage you to reach out to your community association attorney, not only with respect to the hurricane protection, but with respect to the other architectural control issues that I'm going to discuss. HB 59, I don't know really the impetus for this particular law, but it says all HOAs, and this law went into effect already, you must furnish all the owners with a copy of the rules and the covenants by October 1, 2024. Furnish. So if you have the authority to use electronic notice, you have to have something on file from the owner saying, hey, you can use this email address for electronic notice. Then you can distribute all that information electronically. It's so much simpler, so much easier to use electronic notice. It's less of a cost, less of a hassle, less of a burden, having to take documents to a copy center and get all the photocopies made and then take them to a mailing center, or have your staff go forward with all of that labor. You don't want that. So to the extent that you can, I always encourage my clients and just the community associations in general to get consent to use electronic notice. This is one reason why. A big change to the law, though, that resulted from HB 59 is now the association is responsible for furnishing new owners with the governing documents. The law was always that the selling owner, it was the obligation on the part of the selling owner to furnish a full set of documents. Now the HOA is responsible to furnish that new set of documents, or the full set of documents. What's the full set of documents? That is the original declaration, original articles, original bylaws, all the amendments that have been adopted over the years, your rules and regulations. And if you have any other policies or administrative procedures, you want to make sure that the set that you furnish to the buyer is complete. It's really very, very important, regardless of whether those documents are recorded. A lot of architectural guidelines are not recorded. A lot of rules and regulations are not recorded. And you want to make sure that these new owners get all of the information that they need so that they can be compliant and be productive members of the community. And then, of course, this went back and forth in the HOA in 720 a few times, where if you distributed an amendment for purposes of voting, then did you have to distribute the amendment after it was recorded? And the law said originally that you did have to distribute it. Then the law changed and said, no, you can just send everybody, if the text hasn't changed, you can send everybody a link or the information as to where it was recorded in the public records. Here clarifies you must distribute any changes or updates to rules and covenants, especially true when it comes to rulemaking, because rules are not recorded all the time, or maybe most of the time. And you need to publish those rules. And this is if the association has failed to enforce its rules on a consistent and a uniform basis, you may be in the position of wanting to refresh or revitalize those rules. You're going to have to publish them. When I say publish, that doesn't mean solely on your website. That means sending everybody a copy. Sending everybody a copy, as we just discussed, is a little bit easier if you have the permission to use electronic mail. So I'm not seeing your questions right now. If one of the other hosts would like to bring up questions as we are discussing the issues, I'm more than happy to do so, or we can wait to the end, whatever creates a little bit of an easier flow. So I see you, Marielle.
What would you
Just let me
prefer,
know.
Lisa? Because we do have some questions. We can certainly save them. We have
I
a, we
think,
have, okay.
go ahead.
So let's see, if an owner gives approval to have documents provided by email in lieu of USPS, this now gives another owner the ability to obtain their email addresses. How can an owner's email be protected from other owners?
Okay, so that's true. And I've had this issue when it comes to electronic voting and electronic distribution. Once you give that address, Lisa at gmail.com, to the association for official mailing purposes, it becomes part of the roster, and therefore it is accessible to other owners. So what I say to the individual owners, hey, listen, if you're getting all kinds of nasty grams because you have one owner out there or one vendor out there or one person out there, doesn't necessarily even need to be an owner, that just all they want to do every single day is send pages and pages of emails saying what the board did wrong, and what your next door neighbor did wrong, and how this is not maintained and how that is ugly. Well, I'd say you don't have to receive those emails. Block that address. Why would you voluntarily subject yourself to listening to vitriol all day long? And this is true for the directors as well, not if they're official email addresses for, your position as a director, but if the information that is being provided to you upsets you, then in my opinion, why do you want to even see it? That person obviously their opinion would not mean a lot to me. So I may not even want to know what their opinion is. Hopefully
We
that
do,
answers the question.
we do have a couple questions regarding the Kaufman language. Do you
Okay,
believe that
let's defer on that, because that's a
okay.
pretty sophisticated subject. I know people are bringing it up, and it will apply with respect to the architectural control procedures. It will apply when we talk about the vehicle and parking restrictions the most. So I'll talk about it a little bit. But let's start getting into 1203. And here are the CAM requirements. So if your CAMs out there are new jobs for you, both in this act and in 1021. On the HOA side, you're now required to attend at least one meeting per year in person. You must identify who the management personnel is for the community somehow, give the name and the contact information for the manager that is responsible for that community, or if you have an administrative person as the contact person at your management company, you have to make sure that the homeowners have that information. New education requirements, 5 hours of CEU on HOA issues, 3 of which have to include record keeping requirements or record keeping requirements, including the obligation to allow owners access to records. As in addition to notifying people who the contact is for your management firm or some individual management, you have to have a way to identify the list of responsibilities of the manager or the management company. You have to furnish a copy of the contract to the owner upon request. That was always a record that is available for inspection. So the association always had an obligation to allow access to that record. And the HOA would post the CAM info and responsibilities on the HOA website if it has a website, which we're going to talk to. Now, we just talked about CAM education. Let's talk about education for the volunteer directors out there. It's now mandatory. No longer can you just sign a form that says, oh, I read the declaration, I read the articles, I read the rules, and I'm ready to go. Nope. The legislators in Tallahassee have decided that HOA leaders need to be educated. So there's an education class that has yet to be approved by DPPR, because these are pretty much new requirements, for the initial class that you need to take when you first become a director or an officer of a community, of a HOA, homeowners association. In addition to that initial education class, there's 4 hours of continuing education annually if you're a director governing a community that has less than 2,500 parcels, and even more than that, 8 hours if you're a director that's governing a community that has 2,500 parcels or more. The education must include, and I have it listed here, financial literacy and transparency. That probably stems from, well, multiple cases, but the Hammocks case in South Miami, where former directors were arrested and convicted of significant embezzlement and theft. So financial literacy, financial transparency, record keeping, record access, defining procedures, and notice and meeting requirements. There's no reason to believe that 4 hours or that 8 hours, if you're a governor of a community, of a very, very large community, needs to be done in one session. So please do not think that you're going to spend a full day either sitting on your computer with an education class for 8 hours, or going to somewhere and having to sit for 8 hours worth of education in one day. That there are so many educational offerings available from various types of vendors or service providers to community associations. So it doesn't necessarily have to be through attorneys. I mean, there are community association management companies that offer education all the time. There are other types of vendors, accountants, insurance professionals, and even contractors and the like that offer education. A lot of it is online, just like today, so it's very convenient for you. And of course, the DBPR hasn't established, how you're going to account for this, or what you'll need to reflect that you actually went through this education. But while it seems like it's an onerous obligation, it's really not as bad as you think, because if you're attending today, you're somebody that obviously cares about your community. You want to know, you want to stay abreast of what's happening in the law, or with respect to your obligations, or how you can be the best director you could be. And I would venture to believe that a lot of you have already already take 8 hours per year of education. So your lifestyle and practices don't necessarily need to change, although you will be responsible to provide some kind of a record to the association. And if you're required to have a website, post it on your website. So we talked about website. Is it on here? Okay, communities with 100 or more parcels required to have a website by January 1, 2025. Let me tell you something. Most of you have them. A lot of people, a lot of associations already have them. This could be the best thing that ever happened, particularly if you have owners that submit record inspection requests for sport or for fun or repeatedly. You only have certain authority to adopt rules and regulations when it comes to the record inspection process. There's a lot of limitations on those rules. One limitation that has been adopted by DBPR through the arbitration decisions is that you must allow at least 8 hours per month for owners to conduct record inspections. So you can't just say, okay, you're coming on a Tuesday and that's it. You're not coming back for a whole nother month. No, if the record inspection takes more than the allotted time that you've allowed, then you have to let them come back for additional allotted time. And they're allowed to submit more than one records request. So having the website can be a godsend, because if the records are posted to the website, well, that's your avenue, that's your relief. You can say you don't have to have a volunteer board member or a staff member sift through all the records, put them into a file, make an appointment for a specific time and day, sit there and watch somebody begrudgingly look at records, or make comments with respect to the records or what have you. You can just say, oh, they're up on the website, go ahead, here's where you find them on the website, go ahead and look at them. I think it's fabulous. And you have to have that up and running by January 1, 2025. So for the website and the official records, the records are maintained for 7 years unless your governing documents require longer. The HOA also needs to adopt a document retention policy. And if you have a website, post that policy on your website. I very, very much recommend that you have a document inspection or access to records policy also adopted, so that you have procedures in place for owners to follow when they want to see certain records, and that either the board of directors or your management has a clear marching orders when it comes to how record inspections are conducted. The website must include the meeting notices, not only board meeting notices, but member meeting notices. Board meeting notices for all HOAs are now required to include the agenda. Member meeting notices always should have included the agenda. And the documents to be considered for at a meeting likewise need to be posted. So if you're having an owners meeting and you're voting on the amendment, the notice of the meeting was posted at least 14 days prior. And that does not obviate the other forms of notice. Again, it's just an additional notice. And the documents that the owners are considering must be posted at least 7 days prior. Doesn't make sense. You'd probably post them both at the same time, but just in case, you were making some changes to the documents within that 7-day period, and now you have a little bit of wiggle room of when you have, when you post those documents. On the condo side, we're not really talking about it, you specifically must include contracts that the board is voting upon in connection with the meeting notice, or has to be available for the owners to review. I suggest that you do the same. If you're going to have a meeting where the directors are looking at 3 different bids for a project, post the bids there, or at least post information about the bids and the bidding itself. You may not want all the bidders to have the exact details of the other bidders bids because, there's price competition, or maybe the services are a little bit different and what have you. But I definitely suggest that you make those documents available. The more transparent you can be as directors, whether it's a association or a homeowners association, the better you are, because you're the ones providing the disclosure. Owners are I often hear owners are very fond of saying, well, we have no idea what's going on. We have no idea what's going on. You give them all the opportunities that you can to let them know what's going on. And at the end of the day, it's really their fault if they don't know what's going on. If everything's been disseminated through either email or otherwise, it's on the website, you have notices posted wherever in the conspicuous places in the community. Again, put the onus on them or put the burden on them to say why they weren't able to understand what was going on when you gave them all that information, all those opportunities. And there'll be private portions of your website, and parcel owners need to get the password and the username to access protected sections of the website. So that would be if you had financials on there, or other information that was sensitive and that you did not want the general public to know. Other issues, you have to furnish homeowners with detailed accountings or individual ledgers pertaining to their account. So someone says, why is there $25 on my account? Or why you say I'm late? I've paid every single bill. You have to give them their individual ledger within 15 business days. Now, again, the ledgers were records and still are records that are available for inspection. And there's a 10 business day response time to allow access to a record that's an official record. But now here's just an additional level that says, hey, listen, they want their ledger, they can get it. Again, also coming out of that Hammocks case, where the law enforcement was stymied over access to documents and the other investigation techniques that were necessary to prove that these people had engaged in substantial wrongdoing. They were imposing all kinds of outrageous fees and saying it was going to take 6 months to copy all these records. Now, if you get a subpoena from a law enforcement agency, you must provide the documents or access to the documents within 5 business days of receipt of the subpoena. Now, let me tell you something, law enforcement agencies are not ogres. If it's going to take you 10 days, I'm sure they would give you an extension under the appropriate circumstances for it to be 10 days. But no longer are you able to, and you were never really able to, in my opinion, kind of ignore the subpoena or provide like one little document or say, oh, we're working on it, we're working on it, we're working on it. You're also, as an HOA, responsible to assist law enforcement as appropriate. That doesn't mean that you're narcs. It just means that if you get a legitimate request from law enforcement for information, I suggest that you contact counsel right away and indicate to law enforcement that, hey, listen, we don't have a problem with this. We're just going to, consult with counsel to see, what our obligations are, whether or not we're subjecting ourselves to any exposure for releasing certain types of information, and we will, assist you to the extent that we can. We won't thwart your efforts to engage in law enforcement investigations. Get rid of debit cards. I don't know how many of you still have debit cards because they were eliminated for condos either 1 or 2 years ago, maybe 2 years ago, but just get rid of them. And it's a criminal offense if you use a debit card for improper purposes, just like it's a criminal offense if you use association money for improper purposes. And the financial reporting, if you have a community of 1,000 units or parcels or more, you must obtain an annual audit regardless of your annual income. And for all other associations out there, less than 1,000 units, it goes by the stated level of income, whether you do a review, a compilation, or an audit. But and the statute allows the members to vote to reduce the level of reporting. So if your community has over $500,000 in annual revenue and the statute says you're supposed to perform an audit and distribute the audit to your owners, the members were able to vote to say, no, instead of doing an audit, let's just do a compilation this year, or let's just do a review this year, or let's just do a statement of receipts and expenditures this year. Well, the law says you can't do that now 2 years in a row. So if you're at the 500,000 or more level, you're going to have an audit every other year. Same thing for the compilation or in the review. If you're less than $150,000, you're still able to provide that list of receipts and expenditures as your year-end financial reporting. That's a pretty big change. So that means that you now need to budget for these audits or the financial reporting requirements and speak to your auditor, because it may not be financially beneficial to you to skip the audit every other year if you're at that level of income, because it may make more work for the auditor to have that gap year where they can't rely upon a previous audit. I don't know the answer to that, whether it would be more cost effective to have the audit every year, but just make sure that you understand that your members are going to be looking for that audit or whatever level of financial report they're entitled to get at least every other year. Well, let's go back to this for a second too, because document inspections or the availability of documents to owners. This is one of the biggest issues that legislators here throughout the state. This is by far the biggest issue that DBPR deals with when it comes to condo or cooperative complaints. I can't tell you how many hours they devote to owners claiming they were not able to access records, or the records didn't exist, or they were manipulated in some way. So the law for HOA now imposes criminal penalties for onerous actions associated with failing to disclose records. So if a director and officer knowingly, willfully, and repeatedly fails to allow access to records, there could be criminal penalties. If the directors knowingly or intentionally deface or destroy or fail to create or maintain accounting records with the intent to harm, that could involve criminal penalties. And if the willfully or knowingly refuses or to release or produce records to escape liability, that is also going to carry a criminal penalty. Records, both on the HOA and the condo side, it's something that the legislature addresses every single year. As I said, it's something that the DBPR addresses on a daily basis. And to the extent that that website's going to help you, I hope that we can kind of eliminate this issue, because I feel that I actually spend a lot more time devoted to records access, records inspections, facilitating access to records than should really be warranted. You want to have those procedures in place so that you're 100% compliant, and you can go ahead and make sure that your members have access to the documents that they want to see. These are not your individual documents. These are documents that belong to the corporation. The members are on equal footing with you as a director to have access to these documents. Now, there are still documents that are not available for inspection, obviously. That really hasn't changed. So anything with personal identifying information, any social security numbers, any medical records, and the like are not going to be available for inspection. That really hasn't changed. So now I'm going to talk about the architectural control issues that arose from HB 1203. I think that you're going to need to take a look at your guidelines. And if you don't have published guidelines, seriously think about publishing some guidelines, what you'll allow and what you will not allow. Relying upon it's never been done here this way before is not going to be a suitable response. I mean, again, these HOA changes or these architectural control changes to the statute don't necessarily eliminate the notion of a common scheme or a common design plan. And there are some communities that have very specific types of architecture. One community I worked with had a Bermudian style of architecture. The roofs were in a Bermudian style, the exteriors were in a Bermudian style. But not every community has that distinct look and feel, and what you perceive as to be conforming to community standards or that would fit in with your community, may be more restrictive than what others would feel or think that would fit into the community standard. So the first thing is interior changes. In an HOA, if somebody wants to make a change to their interior, HOAs are not stacked on top of each other. As long as it's not visible from the outside, there's no reason for you to even be dealing with architectural control. So this one says cannot limit or restrict interior changes to the dwelling, including if somebody wants to install central AC or HVAC changes. I don't know what other HVAC changes would be other than the central AC, if the changes are not visible from the exterior. Here's an important thing. If the association or the architectural control committee is going to deny an architectural control application, an application for modification, then not only do you have to deny it in writing, you have to specify what about the application does not conform to your architectural guidelines or to whatever the terms or conditions are in your declaration of covenants. So easy example, somebody wants to put a fence on the perimeter of their lot and there's a 5-foot setback. They show you the plan that shows the fence on the perimeter. Easy. You say, no, we're rejecting it because the fence is not set back 5 feet from the property line, and that is required by Article 2, Section 5 of our architectural guidelines. That's exactly what you'll need to do. You'll need to say what is non-conforming and where the rule is that you're relying upon, a rule, guideline, architectural item. You have to apply all the guidelines and standards in a uniform and consistent basis. Another part of this law, you cannot prohibit artificial turf. This was from last year, but some items have been added to it. Artificial turf, boats, flags, vegetable gardens, clotheslines, recreational vehicles on the parcel, if they're not visible from the exterior, not visible from the front, not visible from an adjacent parcel, not visible from adjacent common areas, or not visible from community golf courses. So I haven't had a lot of cases that involve this because the law, of course, changed last year, but there are a lot of questions that arise as a result of this law. What if it's visible from the second floor of an adjacent home? Does that mean that it's allowed or prohibited? But the intent was to allow people to store things in their backyard, and as long as it's not bothering anybody else, then it shouldn't bother the HOA. Like vegetable gardens, clotheslines, recreational vehicles, kind of hard not to be able to see from the front of the from somewhere else outside the parcel. But small things, play structure. Somebody wants to put up a jungle gym. If it's not visible from the front, the side, the back, or community golf course or common area, then the legislator are saying, you guys don't have you can't say no if it's not going to bother anybody. This brings up that Kaufman issue. But when we say Kaufman, the Florida and the federal US Constitution prohibits adopting laws that interfere with contractual rights, unless there's some overwhelming public policy and a few other exceptions. So contract rights, your declaration, your guidelines are an exhibit to your declaration, your architectural guidelines are an exhibit to your declaration. That's the contract that they're talking about. And your contract may say no recreational vehicles allowed on property, or no, I'm sure they they probably don't say vegetable gardens, but they may say certain things, very, very specific things. And now this law comes along and says, oh, well, despite what your governing documents say, you have to allow it. Well, if the issue is remedial or procedural, then it's not considered an infringement on your contractual rights. But if the issue is substantive, then it could be considered an infringement on your contractual rights. And where I see this really easy example on both the condo side and the HOA side is in the changes to the statute that prohibited associations from changing rules regarding leasing, whether it prohibited association from adopting new amendments to their declaration that prohibit leasing unless the owners of the parcel agree. So that created a two-tier type of ownership structure in condominiums in 2014, I believe it was, when that law changed. And it just recently changed for HOAs. And that's a substantive issue. Do you want to allow do your owners allow parcels within their communities to be leased? Or do the owners in your community want every parcel to be occupied by an owner or not occupied? I mean, that's a substantive issue. So the question is whether or not changes like these and like the other architectural control issues we discussed, the installation of fuel storage facilities, interfere with the substantive contract right, and thus, therefore, cannot be enforced against pre-existing contracts. And the only way you're going to get a definitive answer on that question is if somebody brings that issue to court. Most of the communities that I represent would not have the gumption or desire to engage in a protracted legal battle, as well as fund the protracted legal battle over whether or not they can enforce a restriction that prohibits a vegetable garden in someone's backyard. And this was true when it came out with Florida friendly landscaping, although that overcame the Kaufman objections because that was a compelling public interest. Another compelling public interest that overrules this notion of after created laws, discrimination laws. Now, you don't have them now, and hopefully none of you have them now, but back in the day, a lot of HOA declarations contained racial restrictions, they contained religious restrictions, and those are not enforceable because we have federal and state laws prohibiting discrimination. In fact, there's a law on the HOA statute that was adopted either last year or a few years ago. Actually, it had to be more than last year, that says an HOA, without having to go to its members to vote to change a restriction, the board of directors can actually record something in the governing document saying, hey, we know that it says something that's in violation of the law in our documents. We're eliminating that, everybody of public record, because it's going to be recorded in the public records. That's not enforceable. We know it's there. Don't worry about it. So that's a case that talks about where an after created law could actually override your documents. And the question here, do these provisions, I'm going to get to the vehicle provisions as well, do they override your existing documents, your existing rules, or your existing architectural guidelines? So the case I talked about before, and regarding the fuel storage, here is the case information about the case law that I remembered when I was looking at the laws. Hidden Heart of a Revasso. It's one of the seminal cases in community association law about rulemaking for HOA community associations, condos, and HOAs. So the generalized rule for board-made rules is that, one, the board has to have the authority to make the subject rule. Rulemaking does not just come out of thin air. There has to be something in the declaration or other governing document that gives the board the authority to adopt rules and regulations or change rules and regulations regarding the use of the property or administration of the association or exterior changes or and the like. The rule cannot conflict with anything that is provided for in a document of higher priority. So whether that right is patently stated in the declaration typically or reasonably inferable from the declaration, if you have a rule that's adopted by the board, even if it's been in place for 10 years, and even if it's been followed for that 10 years, the rule is going to fall because if challenged, because the declaration is of a higher authority and the owners are entitled to rely upon the rights afforded by the higher authority. What's an example of that? I see it with pet restrictions all the time. The declaration will say, no pets are permitted without the approval of the association. Then I go to the rules and regulations and it says, no pets allowed. Well, the declaration said the pets aren't allowed unless you get approval. So that applies that pets will be allowed, or at least some types of pets will be allowed with approval of the association. A rule that says absolutely no pet whatsoever conflicts with that right that's afforded by the declaration. We're not talking about reasonable accommodations here today, so no emotional support animal questions, please. And the rule has to be reasonable. Now, reasonable, that's really hard to define. So the way this case law defines it is that it's rationally related to a legitimate association objective. No green cars. I mean, is there a rational objective to eliminate green cars from your community? That's never been a rule that anyone's ever adopted, as far as I know. But I doubt that that would be a rule that would be considered rationally related to a legitimate objective. So in this particular case, the Hidden Harbor v. Vaso, they did have well water that was furnishing common elements and their irrigation and what have you. And the well water was at one point experiencing some salinity and there were some problems with it. But I think they got that under control. Owner comes along, and this was a mobile home condominium. So the condominium was the actual square of land, and the mobile home that was on top of it was the dwelling in which the owner lived. So that square of land actually belonged to an individual owner. Owner comes along, they have their own landscaping. They want to dig a shallower well so that they have extra water. So when they want to water their landscaping or whatever they want to use their water for. And the board of directors thought about it and they said, no, we don't want you digging another well on your lot. Why? We fear that they're having additional wells in the community will increase the salinity of our wells, and we can't compromise our wells. We also feel that if you're digging a shallow well and it has certain minerals in the water on a more shallow basis, it's going to start staining sidewalks and common areas. And we also don't want 100 more wells going up in this community. The court took a look at all of those justifications and said, well, yes, while you have to have that reasonable standard, none of those, the prohibiting a well would not result in these consequences. So unless you have some basis to conclude that your rule is going to achieve your legitimate objective, and it doesn't have to have a scientific basis, but again, you have to have a reasonable basis to conclude that your rule, your regulation is going to achieve that objective, then you're going to be subject to challenge, and you may find yourself on the losing side of a lawsuit if you try to enforce those rules that have not been vetted through this process. So keep that in mind when you modify your architectural guidelines and restrictions. Think about why you want the rule that you want. Why do you want that 5-foot setback? Why do you want only shadow box fences, or why do you want to prohibit chain link fences? And aesthetic reasons are certainly valid reasons for the board to rely upon, because many people choose to live in an HOA because of the the nature, the aesthetic nature, the fact that everything is maintained, the fact that there is uniformity of appearance. So maintaining a uniform appearance, maintaining the aesthetic quality or nature of your community is a legitimate justification, but really think about your rules when you change them, or your guidelines when you change them, and with this critical eye, so that you can justify the rule if it's later challenged by somebody. So here we come to the parking and vehicle regulations. This is where I've seen a lot of umbrage on the part of community leaders, including some community association managers. So your vehicle and parking restrictions. The new law says you can't prohibit parking a personal vehicle, including a pickup truck, on the driveway of the owner's parcel or other legitimate parking areas. You cannot prohibit owners or tenants and invitees from bringing or parking work vehicles on the driveway of the parcel, regardless of signage. So that's why I put the picture there of this electrical contractor's vehicle. When vehicles are with signage, I wanted to find a picture of the Truly Nolan vehicle. I couldn't find one. So work vehicles are regularly prohibited in HOA communities and condominium communities too. They don't want vehicles that have the signage. They don't want vehicles that have construction apparatus on them, or tools and equipment, or what have you. Now this law comes along and says, no, despite your restrictions or despite your rules and regulations, if I work at Truly Nolan and I have a vehicle that has ears and nose and a tail on the back, and it says Truly Nolan with a big fat phone number on the side, I'm allowed to park it in my driveway. Same thing is true with law enforcement vehicles. I remember in the past, there were associations that had restrictions against law enforcement vehicles or first responder vehicles, firefighter type vehicles. I see that less and less now. Most associations like the idea of having a law enforcement presence in the community, but same thing is true. You can't prohibit people from parking first responder vehicles on property, can't prohibit them from parking law enforcement vehicles on property. And the law says you can't prohibit use of motor vehicles within the community, legal motor vehicles. So that means if the people have street legal motorcycles, mopeds, street legal golf carts, they have to be permitted to be operated within the HOA community. You're still able to prohibit commercial vehicles. Yes, I know a lot of those vehicles we talked about, people are in the general vernacular are considered commercial vehicles, but the statute includes a very specific definition of commercial vehicles. And I put the definition right here. A vehicle basically that has 26,000 pounds or more. So I looked up truck classifications and to find out what was 26,000 pounds. I have no idea. And look at this. Class 1 up to 6,000 pounds, 2 up to 10,000 pounds. You see that light utility van. You see that I think it's a panel van. You see that pickup truck there. You get to class 3 up to 14,000 pounds. We're talking about these type of vehicles. 4, 5, 19,000, 6 to 26,000 pounds, and then 7 over 26,000 pounds. That will present, I'm sure, a problem for many community associations. Now, that's just like the law was changed this year, 2024. If this is untenable, if this is completely ridiculous, tell your legislators about it. Tell them they're parking these walk-in type vans or large vans, city delivery trucks, bucket trucks. That's got to be considered a commercial vehicle, I would think. And have them think about modifying the law going forward in the future to give the associations a little bit more latitude when it comes to vehicle parking in the community. And that was within their particular driveway. So you know what? Many of those vehicles are not going to fit within the boundaries of the driveway. So you may not have to worry about it. You may have dodged a bullet in and of itself just with that. Fines. The fining procedures have changed. So there's no fines for, you can't levy a fine for leaving your garbage can out 24 hours from the pickup day. So if your pickup day is Tuesday, somebody puts it out on a Monday, the garbage is picked up on Tuesday, then the owner doesn't pick it up until Wednesday, that's not a finable offense. Same thing is true with holiday decorations, unless you send them a written notice saying, hey, our rules say that after 10 days after the holiday, you have to get rid of your holiday decorations, holiday lights. You still have them up. We're going to give you another 7 days to get rid of them. If after the 7 days notice expires, at that point, you can start your fining procedures if the owner's still ignoring you. The fining hearing has to be held within 90 days of the notice of the intent to impose the fine. Doesn't specifically say that the hearing must be held, but in my opinion, the way it implies that a hearing must be held because you have to furnish the person sought to be fined with the written committee findings within 7 days of the hearing. So there will be no written committee findings if there is no hearing, which is why I'm going to be telling my community, my HOA clients, that they have to have the finding hearing. I mean, again, it could be held on the same day as any other board meeting, so the notices can go out on the same time. And if the owner doesn't show up for the fining hearing, well, then the fining committee is only going to listen to one side of the story and are going to issue a recommendation approving the fine. Marielle, got a question on this?
We have so many questions, Lisa, because you're doing
Okay.
such a great
I bet.
job. Before we jump into that, I just want to let everybody know, I know Lisa will stay on for a little bit to answer some of these questions. But we have the evaluation form in the chat right now. So if you go to that link and you fill it out, whether while you're still on or afterwards, ideally, once that's submitted, the ending page, once it's submitted, will offer you to have access to the slides, to get in touch with Lisa. You have all kinds of resources once you fill out that evaluation. I know we have some questions of, will the slides be made available? Will the recording be made available? The recording will be made available on the ACE by TSK site in the next couple of days. I know there's so much information, so people want to be able to refer back, which I totally appreciate. There's no way we're going to get to all 78 questions. I don't know, Lisa, that you can see these questions. I'll go through them. There are some emerging themes in what you guys are asking. So I've dismissed a couple that are just redundant. Somebody may have asked that question already, so don't think that I missed it, but we have some themes emerging, so we will get to some of these questions. But I'll kick it back to Lisa for now, and maybe in a couple minutes, we'll start with some questions.
Right, and this is why we divided the HOA and the condo, because there's just as much to learn about the condo stuff this year as there is for the HOA. So we have plenty of time. I mean, we have some time for a holdover. We'll go through many of the questions. I only have 2 more slides. Actually, this is the last substantive slide, but there are criminal penalties added to the HOA statute. I think they're pretty self-evident. I mean, if you're going to take a kickback, anything of value for which the compensation has not been paid, well, I think you understand that that is not right and that is not legal. So kickbacks now specifically prohibited and also specifically carry these criminal penalties. The same thing is true with fraudulent voting activities. Fraudulent voting activities a little bit more difficult to define, but you'll, just like obscenity and the Supreme Court of the United States, you'll know it when you see it. So if you're really engaging in malfeasance when it comes to the election and encourage eliminating votes, changing people's votes, pressure, engaging in major pressure campaigns so that people feel coerced into voting a specific way, then, there could be criminal penalties associated with it. And this is one of the things that the law enforcement found was deficient in the law, would not enable them to initiate charges based upon the fraud statutes that were already, fraud and forgery statutes that were already in place. So now there's a little bit of there's definitely an intent to rein in any problematic behaviors in community associations, particularly when it comes to alienating your owner's right to choose their leaders. So with that being said, we've come to the end of the prepared comments. Let's go back and let's start looking at some of the questions. I'm gonna stop the share.
There are
What do we
some kind of
got?
themes emerging, Lisa, with what people are asking. Of course, we're a little bit all over the board, but some of the themes, people really are hungry to understand that new board education requirement, whatever you know about it at this point, because I know it's brand new and probably still as an industry making sense of what the requirements are. People want to know if that initial board education satisfies that requirement. They want to know when the deadlines are. Anything you can share about that? There are a bunch of questions.
Well, it's within 90 days of the board member being elected. I forget offhand if you're an existing board member. If you're an existing board member, I would venture to say, again, I can't know this because it hasn't come to fruition yet, but I would venture to say if you have attended a DBPR approved HOA board certification class, then that should be acceptable. However, the other education, so that the certificate is one thing. There's other education that 4 hours for most of the HOA directors, most communities have less than 2,500 parcels. That has yet to be determined. And I would assume that the DBPR will be approving additional continuing education classes for the specific reasons that were those specific items that were addressed in the statute. So that financial literacy and transparency, the record keeping, the meeting notice requirements, finding procedures. I know that our HOA and condo education already includes all of those issues. So we may just have to go through another approval process with DBPR, and they may be inclined to approve the same exact materials that we already have.
We also have a lot of questions about emails, the emailing documents versus things being on the website. And, I know you talked a little bit about this. It says, must the website be available to the general or just our residents? We have a few different questions about this.
Okay, so the website does not necessarily need to be available to the general public. So if you want to have a protected website where basically your landing page comes up and then every other item it requires the password, that should be sufficient. It's not in the HOA Act because DBPR doesn't have jurisdiction over HOAs, but on the condo side, the DBPR can ask for access to your website to verify that you've posted all the information that you are required to have posted, and it's posted in a conspicuous way.
We do have a couple questions about owners requesting to see emails. So in this one, is a director's email address part of the official record? And an owner requests to see emails.
Yeah, this is a huge boondoggle, because on the condo side, it hasn't been ruled. I'm not aware of any rulings on the HOA side, but on the condo side, there have been rulings indicating that certain emails between the directors and the manager, between the directors and vendors, do constitute official records that must be made available for inspection. This needs to be addressed. I've been talking about this for a few years. It definitely needs to be addressed. First of all, who's archiving all of these records? And yes, in communities, it might be a little bit easier to make that assumption. If you have Lisa at Happy Land Condo, that's my official record. That's my official email address for my position as a board member at Happy Land Condo. But if I use my Lisa at Gmail, does that mean that it's a condo record, or does that mean that it's my record? And there's legitimate disagreements over that, because I want to email with a vendor over, why the pool service was so lousy last week. Well, that does involve association business, but it's my personal email. It's my, I might not even be copying anybody else on it. It might just be a personal correspondence between the two of us. So this is something that definitely needs to get addressed in the legislature, because it's going to be a huge cost issue. I mean, if it's universally determined that all emails constitute official records, then we're going to get to text messages, then we're going to get to WhatsApp messages, then we're going to get to, comments on Facebook posts or what have you. It could become absurd and very, very costly to retain all this stuff. For those of you out there that have official email addresses for your position, like president at condo1.com, I encourage you, first of all, I encourage you not to say anything off color in those emails, that could be potentially exposing the association to liability. But secondly, I do encourage you to have an archiving process for those emails, because those emails, if it's president at condo1.com, that should not involve, where you're going to dinner tonight with your friend or spouse. It should not involve what you bought on Facebook or bought on Amazon that day. You should not have like your medical records, like if your doctor sends your blood test results. So that is not going to have your personal correspondence on it. And in some circumstances, they will be considered official records. And if there's a complaint to division on the condo side, the division has, in my experience, required associations to produce email records. And it was cumbersome and costly. We had to, the association in that particular case had to hire a computer person to download these email records from, I think it was a Gmail type of a site. And it was not an easy thing to do, but they did it, they downloaded it, and they made them available for the owner. And the complaint was closed upon compliance at that point. Big issue, big issue.
Thank you for addressing that. We have a couple questions about homeowner portals serving as a website, with an owner login. Does that satisfy the requirement? And then similarly, if the property management company is providing a website or a portal, does that satisfy that requirement?
Okay, so if the property management company is hosting it, and it's dedicated to your community, in my opinion, that's fine. The HOA statute didn't specifically reference portals. I think that might have just been an oversight. The point being here, and again, I can't know because there hasn't really even been implemented yet. But the point being here is that there's a way for your owners to get access to the records, really access to information and access to records, so that there's a place that they can go where they can know all the meeting notices are posted, where they know all the insurance policies are posted, where they know if you have the financials on there, where they know they can check on the status of their account, they can check on the status of association financials. Again, the whole point here is for transparency and to enable the owners to have a little bit more control or say or knowledge of their community association operations.
We have so many great questions here. One of the questions that I think is interesting, what if the board does not comply with these requirements? Who is enforcing them? And then I imagine that is everything from proper communication of documents per the having the website, but also potentially like the new education requirements for board members.
I mean, you don't have a governmental agency that is charged with the responsibility of enforcement. So it's, with the exception of election type disputes, election and recall disputes, it's all on the private sector. So it's self-enforcement, meaning through the court system if necessary. I mean, if voluntary compliance is not achieved by other means, ultimately you'd have to file a lawsuit. Before you file a lawsuit, you would notify the association that you're willing to participate in the pre-suit mediation that's required as a prerequisite to filing a lawsuit. And if they don't participate in the pre-suit mediation, or it's not resolved at the pre-suit mediation, then you have remedies available through the court system.
Thank you. Here's a quick one. Are credit cards acceptable instead of debit cards? we had a slide
Yes,
about.
there's no, the statute does not prohibit credit cards, and therefore you may have a credit card.
Okay. In the beginning stated something about HOAs with greater than 100 units slash lots. Do any of these rules pertain to HOA with only 60 units?
The website requirement does not. So what is it, 100? It's 100 parcels for you to have a mandatory website.
Okay. Is the audit to be certified by an independent CPA firm or simply an audit of HOA supplied financials?
Well, no, an audit is a term of art, so you have to have a CPA prepare an audit. We're not talking about an internal evaluation of your existing financial operations. We're having an outside auditor prepare the audit. But yes, the information ultimately comes from the association or from management, because that's the only way the auditor can know what you've done for the entire year.
We have a couple questions about zero lot lines and some of the kind of last slides that you mentioned. Let's see some specific questions. How does this affect HOA homes with zero lot lines? There are a couple about this.
Well, the zero lot lines, I think they're talking about the architectural control restrictions and the things in the backyard. So if it's a zero lot line and there's a fence, then you could either see or can't see. But if you're, now I can understand, because if you have a zero lot line and you have to allow access to the next door neighbor, does that mean that the next door neighbor can see it, or that is it visible from the adjacent lot or not visible from the adjacent lot? So that's a question that remains to be seen. There's a lot of open questions when it comes to how this will actually play out in community associations going forward.
We have a couple questions about restrictions on parking in reference to the Kaufman language. A couple of these. So it just says, how about restrictions on parking in reference to Kaufman's language or Kaufman law with parking regulations?
Yeah, I mean, that's basically it. The question is, are these laws enforceable? Are these laws enforceable? Does that, if you have an existing community and you do not allow vehicles with signage, I'm going to pick on the easy one. You do not allow the Truly Nolan guy to park on his lot, or you do not allow the contractor that has, all the lights and the equipment and the signage on the sign to park on their parcel. Does that apply? Does that apply to your community? And really, the only way that it's going to be determined is through the litigation process. So there's a very long wait on that, because something has to go through the trial court and then up through the appellate court, and the parties that are involved have to have the gumption or have to have the fortitude to want to spend the money on it and to want to, devote the time and the resources to it, and to attack it that way. So the answer is, they're very good. There are certainly arguments that many of these provisions should not apply to existing communities that already have prohibitions in place. But the practical reality of it is that you're going to need to deal with these provisions in one way or another. You're going to have to either take a stand and say, nope, we're not going with it, or you're going to have to make accommodations in your rules and regulations.
I have to read this one. Lisa is always very good, but this presentation is one of her best. Thank you so very much. Can't wait for the condo version. I can't wait either. This was so great. This one, she does have a question, and again, it's kind of in this new, education requirement. Will previous board education classes / certificates count towards the new 4-hour requirement, or is this a start over education role? We had a couple other questions of, if you've been a board member for potentially decades, do you have to, fulfill this education requirement?
Yeah. No, it's hard for me to know. So I don't know whether or not the existing classes will count towards those education requirements. There are many of them that should. I mean, really, the classes, I mean, you already have classes out there specifically on fining. You already have classes out there specifically on record keeping. You have many classes when it comes to financial issues, how to read your financial statements, or, how to put together a budget, or, what are the requirements for year-end financial reporting. So I would venture to say that many of them will count and may be recertified to count, but again, it's hard, it's impossible for me to know. Now, for
Not, I
you
appreciate you
directors that have been on
touching
your
on
boards for 20 years, you're not exempt. You guys still have to go through the education.
I imagine this would be your answer, but we have so many questions about it, and I totally get it, you guys. It's brand new. Obviously, we have Lisa here, so you have to ask the questions. So I appreciate that. A couple more questions about parking. I don't know if this is similar to your answer already, but there's about 3 questions here. Can HOA prevent or restrict parking on the street, overnight parking, or parking on the grass? It's 3 questions in one.
Right. No. Most of those provisions, and you hate this answer, depend on the governing documents of the community. Now, if you're a community with private roads, most of the time the governing documents will give the board of directors the right to make rules regarding parking on the streets. I would say practically universally, the declarations that I review for HOAs all prohibit parking in non-parking areas, meaning your front lawn, the grass, okay, is not a parking area. But parking on the street, there's a lot of factors that are involved. Is it a public street? Is it a private street? What do the documents say about rulemaking or control over the streets? Overnight parking again. So you have to communicate with your community association attorney to determine whether those restrictions are still valid, or whether they can be fortified in some way, or whether or not you're running afoul of the requirements. But I don't see this law really changing those issues. Parking on the street and parking on the grass, I don't see it changing that issue. Whether or not you can park on the street, if your community already prohibits parking on the street and is legally entitled to prohibit parking on the street, then I don't see how this law changes that or allows overnight parking on the street.
What about when it comes to restricting vendor vehicles, either at certain times of the day or potentially over the holidays? Can the HOA
Oh,
restrict?
yeah, I'm sorry. I didn't even, I neglected to mention that some HOAs, do not allow unlicensed contractors access into the community. And this law says that the HOA cannot interfere with the owner's right to contract, meaning that if I want to hire an unlicensed person to perform work, and they're coming to the community and they have a truck that says electrician, and you can't demand to see their copy of their license, and you cannot refuse to allow them entry if they're not licensed. That's another issue that may run afoul of the Kaufman type issue.
I mean, there are so many, questions and kind of offshoots of the things that Lisa spoke about today. I want to be really respectful of her time, and also you guys, whoever's still on here. Wow, 234 of you, incredible. I just want to say really thank you so much. And I also want to encourage you guys to reach out to Lisa. You see her email is right on the screen, but once you complete that evaluation form, you'll also have an opportunity to connect with her. Obviously, she's a wealth of knowledge. Every single time I hear her speak, this is the response. So many questions, so much good feedback. So we really appreciate this. This was specifically for HOA. So all of the condo questions, save it, and we will come back later in the summer to have Lisa talk about specific condo information. So make sure you guys in the chat grab that link for the evaluation form. Once you complete it, like I said, just as a reminder, there'll be a screen that pops up that allows you to access the slides. And in the next couple of days, you'll also see the recording of this session. Yep, there it is. You'll have access to the slides. You'll be able to email Lisa. You'll be able to connect with ACE. So you have a lot of resources there. So make sure to fill out that evaluation form and get to that last submission page for all those resources. And then Yep, perfect. And then you can visit ACE by TSK right there to make sure that you keep up with all the webinars we have weekly throughout the summer. You can check out the directory with all of our incredible partners and be able to contact them. Yep, perfect. Next week, we have the milestone inspection and structural integrity reserve studies with the Falcon Group. So that's going to be incredible. More questions, I imagine, always. So thank you to everyone. Thank you so much to Lisa. Wow, you really just always deliver and then over deliver. We still have questions coming in. So guys, go connect with Lisa. Go connect with her. Go connect with her team.
Well, thank you, Marioth, and thank you to Ace and to Jeff too, because you do provide a valuable service. The stellar sponsors or participants. So, I mean, the wealth of knowledge from the various entities and the various professions of the sponsors, and I hope everyone that's participated today was able to glean some information from today. Can't answer every single thing. I apologize for that, but I'm happy to communicate with you to the extent I can, and hope to look
and every
forward
time
to,
you give an answer, there's
seeing
more
you.
questions.
I don't see you, but I look forward for presenting additional information, specifically when it comes to the condo issues, because you're going to have questions when it comes to that too.
We already have questions when it comes to that. So it's good stuff. Thank you so much again, Lisa.